Thank you, Mr President. I give notice that on the next sitting day I will move one, that this House notes that A, on the 17th of February 2017 at a public hearing of Portfolio Committee No. 4, Legal Affairs, for the purposes of its inquiry into museums and galleries, several witnesses declined to answer questions regarding the preliminary business case for the relocation of the Powerhouse Museum on the grounds that answering those questions would involve breaching Cabinet confidentiality. And B, on the 9th of March 2017, Portfolio Committee No. 4, Legal Affairs, resolved that the Chair give notice of a motion for an order for papers to order the production of all documents related to the preliminary business case for the relocation of the Powerhouse Museum. 2, that this House notes the following comments in judgments of Chief Justice Spiegelman and Justice Mayer and Priestley in the Court of Appeal in Egan against Chadwick 1999 concerning Cabinet documents. A, Spiegelman CJ held that it is not reasonably necessary for the proper exercise of the functions of the Council to call for documents, the production of which would conflict with the doctrine of collective ministerial responsibility by revealing the actual deliberations of Cabinet, that a distinction must be made between the documents which disclose the actual deliberations within Cabinet and those which are described as Cabinet documents, but which are in the nature of reports or submissions prepared for the assistance of Cabinet, and that the production of documents prepared outside of Cabinet for submission to Cabinet may or may not, depending on their content, be inconsistent with the doctrine of collective ministerial responsibility to Cabinet. B, Mard J.A. took the view that the immunity of Cabinet documents from the production was complete, arguing that the Legislative Council could not compel their production without subverting the doctrine of responsible government, but without exploring this distinction between different types of Cabinet documents drawn by Spiegelman CJ. C, Priestley JA took a different view, noting that a court has the power to compel production to itself even of Cabinet documents, and that the function and status of the Council in the system of government in New South Wales require and justify the same degree of trust being reposed in the Council, and that notwithstanding the great respect that must be paid to such incidents of responsible government as Cabinet confidentiality and collective responsibility, no legal right to absolute secrecy is given to any group of men and women in government. 3, that this House notes that the report number 69 of the Privileges Committee, entitled The 2009 Mount Penny Return to Order, dated October 2013, in relation to the issue of Cabinet documents, the committee A stated that the committee does not necessarily accept the Egan against Chadwick in the final as the final word on this matter, and that the Council does not have the power to order Cabinet documents. The 3 justices in Egan against Chadwick, Spiegelman, Marr and Priestley took significantly different approaches to this issue. The committee believes that the dissenting judgment of Justice Priestley is instructive, and B, specifically rejected the definition of Cabinet information in the Government Information Public Access Act of 2009 as an appropriate definition of Cabinet documents for the purposes of responding to orders for papers made by the Legislative Council under Standing Order 52. 4, that under Standing Order 52 there be laid upon the table of the House within 14 days of the date of passing of this resolution the following documents created since the 1st of January 2013 in possession, custody or control of the Premier, the Department of Premier, the Cabinet, the Minister for Arts or the Department of Justice related to the relocation of the Powerhouse Museum. A, all documents setting out preliminary business case for the relocation of the Powerhouse Museum from Ultimo to Parramatta, and B, any legal or other advice regarding the scope or validity of this order of the House created as a result of this order of the House. 5, that in the event that any documents are not provided to the House in response to this order on the basis of a claim of Cabinet confidentiality, the return list all relevant documents and identify how the provision of those documents to the House would breach the immunity attaching to Cabinet documents as variously articulated in Egan against Chadwick, and 6, that this House regards failure to comply fully with an order of this House for the production of documents as an unacceptable interference with the capacity of this House and its committees to fulfil their constitutional roles.
Well done, Robert. I like that.
The Honourable Courtney Hughes.
Yeah. See what Robert's been doing this week?